appeal in the matter of Campbell and NHS Business Services Authority and matter.
Yes, Mr. Schmitz, we have read the Ombudsman's decision, we have read the judgment, we have read the skeleton arguments and the main regulations. Can I also say at the outset that our provisional view is that we will not hear your tax point for a variety of different reasons. First of all, we don't think we have jurisdiction to hear it. Secondly, it's an issue between you and HMRC, if it ever becomes an issue at all. Thirdly, the place for determining that kind of issue is a tax tribunal, not this court. But if you want to persuade us otherwise, by all means try.
I'll have a go, my lord, so that later on. May it please your lordships, I appear for the appellant in this matter, and my learned friend Miss Naomi Ling appears for the respondent. It's, as your lordships, as the court will be aware, the appeal is brought with the permission of Lord Justice Newey. And it's an appeal against Mr. Justice Zacaroli's decision of the 25th of April, upholding a decision for the Pensions Ombudsman. If I might mention a couple of points of housekeeping. First of all, my lay client is not present because he is unwell.
Right.
I think that the court may have had some indication as to.
I wasn't aware of that, but never mind.
Well, I'll go into that a little bit later on, if I may. And the other point is that my instructing solicitor is not present because, despite valiant efforts, she was only able to force her way onto a train in Newcastle a couple of hours ago, and so she will be arriving late. I extend her apologies.
Yes.
When we applied for permission to appeal, there was included an application for the recoverable costs on either side to be set at zero, and this was supported by a witness statement in the bundle on the dated the 4th of August of last year.
They're limited to £25,000.
That's what Lord Justice Newey ordered. I will be asking for that to be reconsidered for two reasons. One, change of time, and the other, change of circumstances. And the other point will be that there's a technical defect in Lord Justice Newey's order, in that he ordered that it should be recoverable only against me to that extent. And of course, under the rule, the order has to apply to both parties. So, which gives me a toehold possibly to ask for that matter to be considered. If I might make a suggestion, my lords, that that matter could possibly be dealt with at the end of the hearing. But I make an undertaking now that this application is irrevocable, and if the case goes my way, I won't be turning around and asking for costs after all. Right. I've nailed my colours to the mast.
Right.
I should mention one other matter before passing on from this, which is that there is an error in the application that was made to the court in saying that Lord Justice Newey may not have been aware of the contents of the witness statement of August of last year. That was because it hadn't been mentioned in the notice of appeal. That was a mistake, and a mistake on my part, for which I apologise. Lord Justice Newey did have that information available to him. Now, as regards the papers, the court should have a supplementary bundle and a core bundle.
Yes.
And also the core bundle should have as its last. Your lordship was good enough to mention that the court had read the skeleton arguments.
Yes.
My latest skeleton argument is one at the very end of the core bundle, which has underlinings and crossings through. So
yes.
That's just to make certain that that what the court has is the latest
indeed.
version. I'm obliged. Now, if I may turn to the merits, and thanks to my Lord Justice Lewison's observations at the beginning, I can go through them fairly quickly. That there are two principal issues where the Ombudsman found in favour of the respondents, and one where he made there's one where the Ombudsman found in favour of the respondents, and one where he made no finding. He having regarded this in view of his finding on the first issue. And before Mr. Justice Zacaroli, there was again a finding on the first issue, which is why we are here, but no finding on the second issue because the respondent made a concession, albeit not such as to dispose of the issue entirely. The issues as originally framed were: one, if a scheme member, one, has been granted early retirement on the grounds of ill health, two, has elected to receive lump sums in lieu of pensions, and three, has had her employment terminated during her lifetime, will her estate be deprived of those lump sums if at the time when her employment was terminated, she was entitled to untaken holiday leave and died before the expiry of a period equivalent to the period of the untaken leave, commencing on the date when her employment was terminated. The issue remains as originally framed. And the second question is what was referred to as the tax point, though there's more to it than just the tax point. My fault, because I did not give it as much evidence as showing that it comes within the rules as perhaps I ought to have done. But if I may just outline what that issue will be if the court is pleased to consider it. The question is, would an entitlement to a lump sum in any event be defeated if the member did not submit an application form AWH during her lifetime? On this point, the respondent was of the view that there is nothing left for the court to decide, and that one of the reasons put forward as a ground of considering it is unsatisfactory, which is the tax point. However, as I shall argue, an issue does remain because the respondent has conceded only that an omission to file this form can be cured after a member's death. So the question when the entitlement arose and what interest is payable under the regulations would still remain, and that is something quite distinct from the tax issue. Again, I would make plain that I'm not asking that this court resolve the tax issue. The only reason I mentioned the tax issue is to give a reason why a decision on the substance of the regulations which would be helpful to have. There was at one time a sub-issue with regard to the first of these questions. It concerned the effectiveness of Denise's, and Denise is the late scheme member, to election to commute a given part of her pension benefits, where the decision as to whether to permit commutation is a matter for the Secretary of State under the rules. Denise had elected to commute everything under her form AW341. Because any decision on commutation of that part is a matter for the Secretary of State, who has complete discretion in the matter, there was a question as to whether there was anything which the Ombudsman or the court could do to direct the payment of the relevant sum. However, in the light of a letter received from the respondent's solicitors, I can take the court to it, should the court wish, it's to the effect that the Secretary of State always allows such applications. It is now clear that if the court is minded to allow the appeal, all that needs to be done is to direct the application to be considered by the minister, and then it will take its normal course. The basis of Denise's entitlement, I would refer to my skeleton argument at page 6, that's page 151 of the bundle, of the core bundle, of course.
Yes.
And her entitlement, we say, derives from Part E in these regulations, E2A subrule 2B, which allowed Denise, entitled Denise to a pension in the events that have happened.
Sorry, E2,
Yes, I'm sorry, it's E2A.
yes, 2B.
Yes, that's correct. That's in the, forgive me, I've just, I'll direct the court to the authorities bundle, which is, yes, it's at page
Tab 8,
71
yeah.
of the authorities bundle. I'm grateful. The one part where I didn't cross-reference in my notes. And it's subparagraph 2B, indeed 2.
Well, the regulation applies to a member who retires from pensionable employment.
Indeed, that is correct.
That's the phrase that we're particularly concerned with.
Indeed so. Yes, and then there is also E6, which is the which relates to the lump sum to which she was entitled. So we say in addition, and that's at page 93 of the authorities bundle.
Give me that reference again, page 93.
Page 93 of the authorities bundle.
E6.
E6, yes, my lord.
Yes.
And then there's going back to E2A. We are that's at page 72. There are these subparagraphs 7 to 10, which relate to the that part which where the minister has a discretion to allow commutation.
Yeah. Yes.
Again, if I may refer to the core bundle at page 4.
Page 4. Is it your old skeleton? Oh no, sorry.
Page 4 of the core bundle.
Yeah. This is your appellant's notice.
I don't think so. Well, good heavens! I'm sorry. No, that is. I'm sorry. It's the supplementary bundle. My apologies.
Supplementary bundle, page 4.
Yes, indeed.
Yes.
This shows Denise's then estimated entitlement on retiring with a Tier 2 pension, and it's an estimate that was prepared on, as the court can see from the lower right-hand corner of the page, on the 23rd of April, 2018. What I'm doing at the moment is just taking the court through some of the key documents which led to the assessment of Denise's entitlement as understood by the parties and as acted upon by her.
Yes.
And then, as can be seen, there's a choice between a larger pension and a smaller lump sum, and a smaller pension and a larger lump sum. That's besides what the Secretary of State can also commute. Then a figure of 274,000 odd, if the appellant succeeds, has been put forward by the respondent, But it's, the figure is not agreed, but what is agreed is that the court need not concern itself with the minute accounting there. We're not terribly far apart, and it's a matter of calculation anyway. Then turning now, if I may, to the regulations themselves, I deal with that in my skeleton argument at page 151.
Paragraph of the skeleton.
Paragraph
8.
Yes, paragraph 8.
Thank you.
Yeah.
And actually, it's from the immediately preceding page 151. And then what we say, perhaps if the court would wish to have refresh its memory on that, or I can simply give a brief summary as I stand here.
Yes, well, subparagraph 1 is a sort of paraphrase of the regulation. Subparagraph 2 is dealing with subparagraphs A and B, and your conclusion in subparagraph 3 doesn't really deal with the phrase "who retires from pensionable employment." Do we need to find out what pensionable?
Yes, if I may, I'll put that into context. What we say is that the position is very simple, that Denise chose to retire early and to take her pension entitlements as lump sums. Her retirement was approved by her employer, and she was dismissed on the grounds of ill health on the 31st of May 2018, she having died on the 6th of June of that year. The regulations say that a person who retires before normal retirement age because of ill health which prevents her from undertaking regular employment is entitled to a pension. This, I submit, is the plain meaning of Regulation E2A1, as I will show in a moment. But what is said by the respondent is that the position is not so clear because Denise had untaken holiday leave for about 15 days when she left. The respondent relies upon a separate regulation which provides that a member's pensionable employment will be treated as continuing beyond the date when one leaves employment if one has untaken leave. And that because Denise died before the expiry of the period of time equivalent to the leave to which she was entitled, it follows that her employment was to be treated as continuing after the day she had left. And that because she died during the period of the continuation, she never retired, and therefore her entitlement to a pension was never triggered. That's the case, of course, that I have to meet.
Well, I don't think they say that, do they? They accept she retired from employment. What they say is she didn't retire from pensionable employment.
With great respect, my lords, here we're dealing with what happened in front of the Ombudsman. That's what happened in front of the Ombudsman. But Mr. Justice Zacaroli was pleased to allow my submission that there is only one type of employment. There aren't two employments, employment and pensionable employment. And what Mr. Zacaroli said that, but he went on to say that although I'm correct in that, I'm not correct in saying that because there is only one type of employment, when she left, did not stop her period of pensionable employment from running. So for the purposes of the of Regulation E. We're so far. I'm not disputing Mr. Zacaroli's judgment in saying Mr. Justice Zacaroli's judgment in his finding that there was only one type of employment. What brings me to before this court is his further finding that notwithstanding that, the pensionable employment continued, and it continued so as to rule out an entitlement under Regulation E2 capital A. I will, of course, be turning to the text of the regulations in some detail, but before I do so, I would, if the court please, mention two more general points of statutory interpretation, which I propose to go into further a little bit later on. The first is that retire is an ordinary English word, has what is, and as such, has what is known as potency, by which is meant that there is significance in the draftsman's choice of that particular word. And therefore, the court should hesitate before holding, as the respondent appears to wish it to hold, that because a period of employment is treated by the regulations in some circumstances for some purposes as if it were extended, it must follow that where those circumstances apply, a person cannot, for any of the purposes of the regulations, be regarded as having retired. I will be referring to dicta in the recent Supreme Court case of the King on behalf of PACCAR Incorporated against the Competition Tribunal, with which one of the members of this court, of course, is far more familiar than I could ever pretend to be.
Well, was at one stage anyway.
Well, my lord did convince Lady Rose, of course.
Doesn't matter, we actually convinced the majority of the judges who heard it. It was just the wrong four who ended up in the majority in the Supreme Court.
But in any event, the second general point of construction after the potency point is that the court should not find that there is any particular purpose to legislation without good reason. Here, my submission is that the Ombudsman and the judge were too quick to find that there was an underlying policy in the regulations to prevent a scheme member from simultaneously contributing to the scheme and receiving benefits. I will be referring to passages from Benyon on statutory interpretation and submitting that there is no indication in the legislation and there is no evidence that there was some recognized mischief which the regulations were intended to cure. Now, without either of these, in my submission, one looks at the wording of the regulations, and I stand or fall according to that. Turning now to the text of the regulations, I will, if the court would turn to page 71 again of the authorities bundle. It is apparent right from the beginning that the trigger to entitlement is that an employer, a member, should retire.
And there is some authority about retire in different contexts in pension schemes, isn't there, about what that means? Obviously, it depends partly on context, but retire is different from leave or terminate employment, isn't it?
Well, the leave I would submit, and I'll submit later in my address to the court, is is a broader term which includes various things, including retirement. That's that is key to the analysis of one of the grounds on which Mr. Justice Zacaroli found against me. I'm sorry, I forgot the other point that my lady was making.
No, it was just about there being some authority on what retire means, which turns quite often in relation to the specific words of a scheme, but nevertheless there is some authority about retire, I think.
I say I must confess I'm not aware of that, because what I'm fastening on in this particular case before the court is that that is a term which is undefined in these regulations.
Okay.
And therefore, my point on that, to leap ahead a little bit, is that it therefore has potency, which will, in my submission, should lead the court to find that the draftsman used such a well-known word with such a well-understood meaning in common parlance deliberately, and that decision on the part of the draftsman should have a strong bearing on the court, the decision which the court eventually makes in that regard. Unless there's anything further arising out of what my lady has just said, I propose to go on and ask this. So why is there a dispute, since the regulations plainly say a member who retires gets a pension? And the answer is in regulation, as has already been alluded to by my Lord Justice Lewison, to look into that, we have to look at regulation C25, which is in the authorities bundle at page 53. And I would submit that if it were not for that regulation, there would never have been a dispute between the parties of in this case. The court was kind enough to tell me that it had already read this regulation. So rather than reading it to the court myself, I'll simply highlight the following points I would wish to make. The regulation applies in terms when the member leaves pensionable employment or dies. That's right at the beginning, of course. Leaves, and here I go back to what I said in response to Lady Justice Asplin. It's an ordinary English word, and it must include retires along with the other possible forms that leaving might take. What it says, where applicable, is that where an employee retires, her pensionable employment will be treated as continuing if she leaves employment having not taken a certain amount of leave. But what I would submit is that there is nothing wrong in interpreting the regulation thus. Yes, the employee has retired, but for some purposes only, the employment is to be treated as continuing afterwards for a limited time. That does not mean, however, that if the employment continues in this sense, the member has not actually retired for the purposes of E2A, or that her entitlement for a pension has not yet accrued. Come to a point here, which I, if I might flag it, is that because it is Regulation C25 affects the interpretation of pensionable employment, but for the purposes which with which Regulation C is most closely linked, namely quantifying the pension that one eventually gets and imposing the obligation to pay for it.
Well, can we just question that for a moment? If we start at regulation C21, or we start with a heading, meaning of pensionable service.
Yes.
And C21 says pensionable service is service which counts both for the purpose of ascertaining entitlement to benefit and for the purpose of calculating them. So the definition in C2 has two purposes, not just quantification. It's also there in order to deal with entitlements to benefits.
Yes, the answer to that point is in my submission this. that there are minimum amounts of service that need to be completed, before the member is eligible for anything. And that is what is called qualifying service under Regulation C3, and that pensionable service is one of the things which counts toward it. So when this rule says in my submission that it is for the purpose of calculating entitlement, it doesn't mean the ability to have it brought into payment under Regulation E2A, or indeed any of the other parts of regulations in Part E, but rather it refers to that minimum threshold which the member has to surmount in order to be entitled to anything, to have had any qualifying service.
Yes.
Coming back now to regulation, to my skeleton argument, I would ask that the court turn to paragraph 13, where I have summarized the issue, the principal points that I made to Mr. Justice Zacaroli. I would then deal with his answers, and then to the points that I made, and then seek point by point to attempt to persuade the court that perhaps my own submissions are correct. I mentioned earlier, and perhaps it would be helpful if I say it again, that among my submissions was one that the judge should overrule a finding by the Ombudsman to this effect, that the triggering event is retirement from pensionable employment rather than employment in the ordinary sense, and that while Denise had retired in the ordinary sense, she had not retired from pensionable employment. I argued in the court below that there was only one employment, not two, and the judge agreed with that. However, on my other submissions, he was against me. Now, my submissions below, as I mentioned, are in paragraph 13, and I can just go through them very quickly. The first is that an entitlement to a pension ought not to be displaced without clear wording, especially whereas here consideration is given for the benefits. There is no clear wording in my submission in Regulation C25. Retire is an ordinary word which should be given its ordinary meaning. And then 4 is the point about one type of employment which the judge accepted. And 5 and 6, an important point in the context of this case, I would submit, the word deem is not used in Regulation C25. Instead, the word treated is used, which is weaker for the purposes of incorporating a new meaning to a word which appears in a separate regulation.
Why do you say that?
Treated means dealing with it as if, dealing with a concept as if a certain thing applied.
Isn't that the same as deeming it? Isn't that the same as deeming it?
I would submit no, because it is deeming means it is. This is the way it is for present purposes. Treating means, although it may not be this way, we're going to deal with it as if it were. And when you're
that's deeming, isn't it?
Well, I would submit that the treating and deeming are different simply for the reasons that I've stated, I would suggest that perhaps the word treat and deem have a certain legal potency of meaning, which would entitle the court to find that the choice of treat rather than deem meant that the use of the word in a particular of the word that is being treated or deemed, as the case may be, is used in a different sense. The shall we say that the alteration of meaning is weaker with treat than it is with deem, and that is important in a case where when we are dealing with the applicability of a deemed or treated meaning in one section where the deeming or treatment occurs in another.
And so you would say treating is limited to a particular purpose within a regulation, and deeming has a much broader meaning, which would have a greater, wider effect.
I would say I would gratefully adopt that, but I would also go further and say that the effect is stronger. The inference to be an inference is more readily to be drawn from a deeming provision than from a treating provision.
Can I put 2 points to you, Mr. Schmitz? First of all, in Fowler, which is now, I think, the leading case on deeming provisions, the statutory phrase was treated as, and the Supreme Court said that was a deeming provision. Secondly, if you look at Benyon, I think it's paragraph 17.8, they say, well, treated as is just the modern way of saying deeming, and whichever phrase is used, the effect is the same. Now, do you have any authority which supports the proposition that treated as is a weaker form of words than deeming?
I do not, but I will, during the short adjournment, make a frantic search for it. Having said that, of course, that's one of my arguments, by no means my sole argument. And the other point is that even if, which I can say, hastily dusting myself down, is that whichever word one uses, whether it be treats or deems, again, the point can be made, deemed or treated in what circumstances and for what purpose. And both of those words, although as I have submitted up to now one more than the other, both of those words carry with them the meaning that a particular expression will be regarded, to use a neutral term, as having a particular as having a particular meaning, even though strictly speaking it does not have that meaning. Even though it doesn't have that meaning, we will treat it or deem it to have that particular meaning, and then the question arises, where and for what purpose? And that's where my argument gets back on track.
Can we get any help from the fact that C2 comes at a very early stage in the whole of the regulations? I mean, it effectively provides important definitions which are going to be needed for many of the building blocks of what follows in terms of both entitlement and calculation. Is that not perhaps a pointer that one expects it to have anything one finds in C2 to be, as it were, looking outwards and to be not just a bit of internal fine-tuning, but rather, as I say, laying down one of the key assumptions one is directed to make for the purpose of applying the rest of the regulations?
Well, here, if I may mention a remark that Mr. Justice Zacaroli made in his judgment, to have a broad deeming provision hidden, as I think his word used, was the word he used, in this particular regulation is an odd place. It's an odd place to find it.
Well, with respect, I'm slightly questioning that. I mean, to me, it suggest this might be where you would expect to find a wide deeming provision, because if you look at Part C, it only deals with limited but very important topics: meaning of pensionable service in C2, meaning of qualifying service in C3, and then that's it. And then C1, I forget what C1 was, but it's just those three. C1, meaning of pensionable pay and the final year of pensionable pay.
Yes.
So this could, I mean, surely these are general definitions of great importance that you're going to apply throughout the regulations. And C25, when it applies, does have the inescapable effect. One's told to enter an imaginary world where pensionable employment is treated as extended by the period of untaken leave.
Well, if I may, again, what is the effect of that? If I may mention, deal with my Lord Justice Henderson's point. The point is that it's entirely to be expected to find C before D, which and indeed because D governs when it is that one is obliged to make contributions. It is also to be expected that it will be found to some extent to modify E, because E says it links the receipt, the quantification of the pension one receives to the amount of pensionable service one has performed. But what one must remember throughout is that the is that the process of quantifying contributions, quantifying payments is entirely different from the process of working out when one actually gets that money in one's account. And those two greatly different processes should be noted when one asks the question: does this deeming or treating provision make for the require one to wait for one's pension under Regulation E2A? I should mention, of course, that it is Regulation E on its own, without any of the sub-regulations, which enable the pension to be quantified by reference to the pensionable service, the amount of it.
Well, I'm sure you're going to come back to this, and I don't want to take you out of your way, but it's also a striking feature, isn't it, of the critical paragraph, C25.
Yes.
That it applies not only where a member leaves pensionable employment, but also where a member dies. And of course, we're dealing here with a situation where, sadly, Denise Campbell did die. And in that situation, the effect of the deeming is to treat pensionable service as carrying on for a period after the person in question has died. Now, that is a pretty extreme piece of deeming, but it's unquestionably there because it's stated in so many words in the deeming provision itself. So this is a very potent piece of deeming, is it not?
Yes, it is. However, again, the question which one comes back to is deemed for what purpose? And here the pension the pensionable employment will be deemed to have continued, and I do not dispute that the pensionable employment is deemed to have continued. What I do say, however, is that that does not detract from the fact, even if the pensionable employment is deemed to have continued, it does not detract from the fact that the person has retired from it. One can retire even if there are some financial consequences being worked out during a run-off period.
But you have to confront the meaning of pensionable service in C2, which is C2.1, which is dealing both with entitlement and calculation.
Oh, as I endeavoured to answer that point, the entitlement referring to there is not the entitlement to draw it under the totally separate regulation of E2A. It is to get over that initial hurdle of whether one is even in the scheme in the first place, whether one has pensionable employment. You don't have pensionable employment unless you have unless there is a minimum period of pensionable service which one has undertaken. That's my my answer to my lord's point. So again, just coming back to round off the discussions that we've just had, the question, although that potent piece of deeming is undoubtedly present, and there is therefore a provision which I have to deal with, which says that the pensionable employment is treated or deemed to continue. The question still arises as treated where in the regulations and for what purposes. The seventh point is one which I have since abandoned, and I needn't trouble the court with that. And 8 is there I deal with Part S, which I will go into in some detail later in my address to the court. But what I wish to say here is that neither Part S nor anything else in the regulation supports the finding that there is a policy of preventing simultaneous receipt and contribution and contribution to pensions, receipt of and contributions to pensions. Now, my summary of the judge's findings, and here I was merely outlining the points that I was seeking to make before him, but my summary of his findings is at paragraph 14 at page 156 of the core bundle.
Yes.
As I've mentioned before, he found in our favour that there was only one employment, not two, but it could still be the case that even if there is only one employment, and this is, as he found out, pensionable employment as per the regulations, the effect of C25 would nonetheless be that the employment will not have retired until the period added on for untaken leave has expired. I then go to I have prepared a table which is at page 160.
59 starts.
59, I'm grateful. And now, again, I've summarized the judge's findings and in the left-hand corner and sought to answer them on the right. The first is that the effect of it is if the extended definition is only relevant for the calculation of pensionable service, the concept governing calculation of benefits and contributions, why then did the draftsman only refer to pensionable employment as opposed to pensionable service? And my answer is that pensionable service comprises many elements, but the only one affecting employees under Regulation C is pensionable employment. And I will go through in Regulation C1 which is at, sorry. Yes, at page 47. Yes, sorry, that's the beginning. The part in point is at page 52.
Page 52,
Yes, it is.
that's C2. 52, is that what we're looking at?
Yes, yes, it is. I'm so sorry. Did I say C1? I didn't.
You did.
My apologies. Yes, it's yes, it's C21, and then there
Yeah.
are these lettered subparagraphs. And you can see that it's it gives the meaning of pensionable service, and then and my point is that pensionable employment is the only type of service which these regulations really touch upon, because as you can see, C deals with war service, B deals with previous regulations, and so on and so forth, and that in my submission answers the judge's point as to why the term employment, pensionable employment, should have been used rather than pensionable service.
Well, in A, C1A, it's saying that it includes any period of pensionable employment in respect of which a member contributes to the scheme.
Oh yes,
Yeah.
yes. I mean that if I may say so, is my is my point. That's the one which is appropriate in cases such as what we are dealing with, when the others drop away, which is why there's no mystery in the draftsman's choice of the word pensionable employment rather than pensionable service.
So if you retire from your job, to use a neutral word,
Yes.
but you have untaken holiday pay, your pensionable employment is treated as or deemed to continue, one consequence of which is that your pension contribution during that period of untaken leave will continue to be paid under Regulation D. Is that right?
Yes. Yes, it will. This is the working out of the during a runoff period of the financial consequences, but that doesn't stop someone from having retired. The next point in my table is where the judge said, in effect, that the extension in C2 has effect outside of Regulation C. For example, C25 provides that the payment for untaken leave is treated as pensionable pay, and pensionable pay deals with pension contributions. It's that out of which pension contributions are payable under D1. That indeed the point just made by my Lord Justice Lewison. And moreover, pensionable employment is defined as NHS employment in respect of which the member contributes to the scheme. This point points, so the judge held, to an extended definition in Regulation C2.5 having effect beyond the scope of that particular regulation. I do have an answer to that point, which I hope will find favour. Which is that I'd repeat first of all the point that just because a provision has some effect beyond the regulation in which it appears, it does not follow that it has effect everywhere in the regulations and for all purposes. There is a great difference between, on the one, quantifying what one has earned and imposing an obligation to pay for it, and on the other hand, stipulating when it is that one is entitled to have it brought into payment. I'd also add that C25 is not a definition. Again, it is, and I will see if there's any point to be made of the fact that they've used treated instead of deeming. But I will pass on that for the moment. The third point, the judge said that there is force in regulations. There is force in the point. That's item 3 in my schedule at the halfway through page 161. There is force in the point that the regulations as a whole create a mutually exclusive distinction between periods where members contribute and periods where they receive benefits. My answer to that is that there doesn't appear to be anything in the regulations which creates that distinction. The Ombudsman did refer to Regulation S, which, but on examination, I would submit that it creates no such distinction at all. And to that end, I would ask the court to refer to Regulation S, which begins at page 154 of the bundle. Regulation S1, which applies to what's called normal retirement under Regulation E1, and also applies to E4, early retirement with consent, and E5, early retirement with an actuarial reduction. It does say in paragraph 3 that the pension shall cease to be payable, albeit temporarily, but only if the member has returned to employment within a month of leaving. It says nothing about a person with one of these pensions coming back later. And though it's a matter of speculation, I suppose it can be said that somebody who retires or purports to retire and then comes back within a month won't have retired at all. And that's the high watermark of any case which says that Regulation S supports some broad purpose in the regulations, not to allow simultaneously the making of contribution and the receipt of benefits. If I may turn to S2. This is, in my submission, quite an interesting one. It applies to, not to my case of sorry, it does. If you look at paragraph 1, subparagraph B, little Roman 1, it does apply to any of the regulations E2 to E3, so therefore it would seem to catch E2A. And what it says, as the court can see from the very title of the regulations, reduction of pension on return to NHS employment, not abatement, not elimination, but it's reduction. And how it works is is to be seen in starting in subparagraph 3. The member's pension will be reduced by the appropriate amount. The appropriate amount is the difference between the member's previous pay and the aggregate of. Now, rather than my gabbling through these through all of this verbiage before we mercifully get to subparagraph 4, I would merely take the liberty of, I apologize, maybe I'd better turn turn off my iPad. So we're not disturbed. I would merely just direct the court's attention to a few underlined passages that I have here, and then say what, in my submission, the effect of this is. For the actual detail of the way the reduction is computed is perhaps not of the greatest importance to the.
This is saying, is it, that you can't get more out of the NHS than you got paid in your previous job?
That's one of that. That's so far so clear.
Yeah.
We then get into slightly murky waters. I will take the liberty of telling of saying to the court what in my submission it means. But the most important point here is that one can retire from NHS employment, get one's pension, go back to work for the NHS, get paid for the work one does, and not lose the pension that one has. So we have here a simultaneous receipt of benefits and a simultaneous making of contributions. And so what that does in my submission is to blow a hole in any contention that there is some overriding purpose in these regulations to prevent the simultaneous making of contributions and receipt of benefits. For what it's worth, if I could say what this amounts to, it would say it goes really like this: if what you now earn plus your pension is more than your previous pay, your pension will be reduced by that amount, but only to the extent that your pension has not been actuarially reduced. So what it really catches is the person whose pension has not been actuarially reduced, and who at the same time is quids in because they have been because they are making more than they did in their previous job and getting their pension for it. That is the that in my submission is what this amounts to. It's it took me a liberal application of aspirins before I worked out that summary. But that is the for present purposes, it's enough to say that it does not support the contention that there is such a policy. Moving now mercifully on to regulations S3, unless there's any point on which my lords, my lady would wish to question me on what I've just covered.
We're back to your table, are we?
No, I'm going through the regulations.
Oh, I see. I'm so sorry.
Yes,
Yeah.
just to show that there is the. I don't know whether it's the man who wasn't there or the event of the dog in the incident of the dog in the nighttime, but there's nothing in regulation S or Part S which supports the point that there is.
Your point here is that in some circumstances it is possible to receive both pay and pension.
Indeed so. I would say in most circumstances, there's nothing that really is the circumstances where one cannot receive them are few and far between. I think the only time that you can say that is if is with regard to the regulation S1, where one retires and then comes straight back in. If that being the case, if at any point there are any other regulations here which the court would wish to challenge me on, I'll of course deal with the questions as they arise. Yes. But it may be that I can now pass over those for the time being, if that is the wish of the court. Coming back now to my table, the fourth item. What the judge noted is that the draftsman did not take what the judge considered to be the more straightforward view of simply providing that pay received during the runoff period equal to the period of untaken leave. But it could have simply said this will be pensionable pay, and that instead the draftsman provided that the period of pensionable employment should be treated as continuing for a period during which the member should be treated as still in pensionable employment. And his question, if I may put it rhetorically, is why do that if all you're doing is adding up to the pile of pensionable pay? And the answer in my submission is this, that the draftsman had no choice but to use the device of continuing pensionable employment, because the whole working of the system is based upon that concept. And here we come back to the observation of my Lord Justice Henderson, that why is it where it is? And the answer is that it is upon the concept of and the performance of pensionable employment that the rights and obligations arise. Then there are, and what I would also say is that if he hadn't done it that way, that is the draftsman, he would have led himself into some considerable drafting problems. One can see that if I'll go back to C, to Regulation C, 2.5 again. If one looks at subparagraph A, the member's pensionable employment will be treated subject to paragraph 3 as continuing for a period equal to the period of leave. If one goes up the page, one can say, says here that the benefits will be calculated by reference to a maximum of 45 years. In other words, if he hadn't hooked this into the concept of pensionable pay and pensionable service or employment, he would have had considerable difficulties in saying, but not if you've had more than 45 years service. And then there is also the question of what pension year, for the looking ahead at Regulation D, what pension year are you going to extract contributions in respect of? Because as you can see from Part D at page 56, it says that in 1A, a contribution rate for each scheme year from 2015 to 2016 is the percentage specified in section 2 of the following table, and there is the tariff. Without again linking this whole levying of contributions to the concept of pensionable employment, this there would have been again considerable drafting problems in working out what, in respect of what period would one be would these contributions be levied and at what rate. So it was the most natural thing in the world, in my submission, for the draftsman to adopt this device, and there's no mystery, I would submit, in the draftsman not having instead taken the superficially easy option of saying that whatever you earn is pensionable pay and treated accordingly. So, and then what that leads us back to in my submission is that because this was the most natural approach for the draftsman to take, there is no significance in that for the purpose of saying, well, it therefore applies across the board to all of the regulations, including the critical E2A, which is the regulation that entitles me to pension when I retire.
Yeah.
I now come to item 5. I seem to have mislaid my notes. Here we are. The judge, in effect, said that the draftsman's device of continuing pensionable service necessarily alters the date on which the employment is treated as coming to an end. And in my answer, I've largely touched on this already, 2 points. No significance in the draftsman's using the device for the reasons which I have given. And then one which is the which I've touched on and will go into a little bit later, which is the importance of the use of the ordinary English word retire and the respect that ought to be given to the draftsman's decision to use that simple English word. The next item 6, is that the learned judge said that it is not counterintuitive to find that if 2 members of this of a scheme retire on the same day, one having untaken leave and the other not, the one with the untaken leave should have to wait for her pension. The reason is that the scheme operates a particular definition of pensionable employment. That is, as I understood, what I've understood the learned judge to be saying. But my answer, very briefly, is that a definition cannot make what is counterintuitive intuitive. If one interpretation of the provisions is counterintuitive, that fact will make the interpretation an unlikely one. As I will submit in a moment, it would be unfair to require the member with untaken leave to wait for her pension. Furthermore, I don't have to show that the respondent's reading of the regulations is counterintuitive. All I need to do is to point out that no reason has been advanced as to why the regulations should be interpreted in what I submit is a rather strained way. That strained way being not to treat retirement as it would be understood in ordinary parlance.
Can we just follow that one through for a minute? You've got 2 employees, A and B, and they both retire on, let us say, the 1st of January. And one of them has 14 days worth of untaken holiday and the other one doesn't.
Yes.
So the one without the holiday leave gets the pension and doesn't get any pay because she's already taken all her leave. But the one who hasn't taken leave continues to be paid for that period of untaken leave. So in terms of cash flow, the one with the untaken leave is still getting money out of the NHS, albeit as holiday pay, whereas the one who has taken all the leave is getting money out of the NHS, but by pension. And why is that? What's wrong with that? They're still getting money.
That is, of course, right. but it's but up to a point, because both the holiday pay and the pension are postponed remuneration. They are and they have both been earned. And so my point would be, why should a person who has both clocked up untaken holiday pay and pension, why not get both? I mean, she's earned them both. That's my point. Seven, I believe I've already dealt with, and that's the regulation S point. 8, the judge's point, again, as I interpret it, is that I was wrong to contend that C25 cannot alter the date when the member retires, because by its own terms it is triggered when the member leaves pensionable employment, and it therefore presumes that retirement has already taken place. And what the judge said is that my argument is wrong because it equates leaves with retires, which is not the case, because one can leave pensionable employment without retiring, as where the member opts out of the scheme. My answer to that is that C25, first, it's really 2 points. One is that it's inapplicable because the triggering event in E2A is retires, and C25 does not diminish the potency of that word. But meeting the point on its own ground, I would say this, that if the regulation is applicable, what must be remembered is that C25 is triggered in terms when the member leaves. And leaving can take one of many forms. Where the form which leaving takes is retirement, and only retirement, it follows that the triggering event under E2A will have occurred. C2A goes on the basis that the employee has left. If the leaving takes the form of retirement, the employee has retired. If he's retired, E2A comes in, QED. I can now deal with the final point in my summary of the judge's reasoning, where at 9, where and that's at page 166, the bottom, where it says that there is nothing illogical in the regulations treating retirement from pensionable employment as a term of art, which is capable of occurring at a different time from the time at which in fact, the member leaves pensionable employment, or even occurring after the time that the member has died. The answer in my submission is that it is certainly possible for regulations to do that, but they haven't done it here. Retire, not having been defined, there is no term of art. And because it is an ordinary English word, it should be given its ordinary effect. I will now turn, if I may.
But the question is surely not whether Denise retired, but from what did Denise retire?
She retired from her
employment.
Yes, from her
But
employment.
the triggering event is retiring from pensionable employment.
Well, Yes, indeed. But my point here is that certain financial consequences can be worked out, but that doesn't mean that one hasn't done the simple thing of retiring. In the court below, Mr. Justice Zacaroli, during argument, used this sort of rhetorical question of what happens if somebody says they're going, they've reached the retiring age, there's a party, they've given their carriage clock, and they don't come back the next day. Hasn't somebody retired in those circumstances? I'm not saying, of course, that was his decision. It's simply it was simply a very useful rhetorical device, which I'm happy to steal. That's what one means by retirement. You see, and if to retire from something doesn't mean that there aren't some consequential workings out. I mean, should the day ever happen, I will one day have to purchase runoff cover, but I'll still have retired. That is the point, and the treating and of course it is not a term of art. The retire is not a term of art here. That's essentially why the draftsman's use of that should be, as I say, given effect to. I would now wish, unless either any of your lordships and your ladyship should wish to ask me any further questions, I propose to go on to a passage from Benyon, if I may. And that's at page 312 of the authorities bundle. In fact,
Yeah.
in fact, I would invite the court just to have a quick read of the beginning of 12.3 at page 310, and then there is a quotation from Lady Justice Arden, as she then was, at the top of 311, which I would propose to read out.
What are we looking at? What are we looking for
yes,
here?
well,
The purpose of the regulations or the purpose of regulations C25?
Or the purpose of regulations generally. I'm dealing with now.
Generally.
Yes, indeed, my lord.
Yeah.
It is. It deals with the hesitancy with which the court ought to find that there is a purpose. I don't think I need trouble the court to read beyond the quotation from Lady Justice Arden. There is another passage a little further down, which again I would refer the court at page 312.
Yes.
Thank you. At 312, there is a paragraph which begins, in the absence of any supporting material, whether in the act or an admissible external aid to construction, the court may treat any assertion of purpose with skepticism. As Lady Justice Arden said in P&O Steam Navigation Company, HMRC, There is a reference to the weeklies, which I can give to the court, should the court wish to have it. 2017.
Sorry, this is the footnote. This is the reference for P&O, is it?
Yes, that's right. But the P&O footnote doesn't give the weeklies reference. And
2017.
2017, one weeklies, 4489 at paragraph 60.
60.
60, yes, indeed, my lady.
Thank you.
Yeah.
And in my judgment, one must be somewhat cautious before accepting any assertion of purpose of an Act of Parliament not set out in any provision of the Act itself made by a party propounding a particular statutory interpretation. Of course, I make exceptions for assertion of purpose deducible by implication from the legislative scheme or clearly stated in some material which is admissible as an aid to interpretation. The reason for being cautious is that such interpretations can be self-fulfilling examples of what is sometimes called confirmation bias. Here, what Lady Justice Arden may be referring to is that the danger that someone may light upon those features which confirm a preconceived idea and ignore those features which do not. And then there is, again, I would invite the court just to read a little bit further to the end of the quotation from Lord Justice Baker in the Buskovich case.
Yes.
Here, in this case, there is no evidence of any intention to compel a person retiring with untaken leave to wait for a pension. Payment for untaken leave, and this is the point that I made in response to my Lord Justice Lewison a few minutes ago, payment for untaken leave and payment of pension are both forms of delayed remuneration. Why shouldn't she have both, as she's earned both? Where is there an injustice which needs to be remedied by an interpretation of the regulations? And moreover, any increase in the value of the pension attributable to payment for untaken leave will have been paid for by the member out of the payment received for that leave. And also, the amount of the pension and the amount to be taken out are calculable the moment the member retires. There is no need to wait. Anyone who says that there is some discernible purpose whereby she should have to wait also has to reckon with the decision by the Ombudsman himself. That's at C138 at paragraph 88. Sorry, C, I meant the core bundle. So core bundle 138. And it's paragraphs 87 to 88, especially 88, where the Ombudsman said, my decision has not been made on the basis that the effect of the regulations is fair in all cases. I consider Mr. L, that's the pseudonym that he adopted for my client, Mr. Campbell, that Mr. L's complaint and the decision that I have had to reach in respect of it highlights the need for the regulations to be looked at afresh. Mr. L's complaint is the latest of a number of cases of this nature. So what this all bears on is no mischief. No mischief, no aids to construction which compel this particular interpretation, and therefore no policy to prevent these two from being separated, these two events, contribution and receipt, from occurring simultaneously. No such purpose is to be discerned in this legislation. So I now come, I'm so sorry.
One of the, it's true, the deeming provisions always, in my experience, give rise to difficulties, and this case is no exception. But one of the key aspects of the guidance that has been given in many cases is that when you were told to imagine a state of affairs contrary to reality, you then normally have to imagine the consequences that flow naturally from that deemed state of affairs, unless that then takes you into territory which is obviously outside the scope of the deeming altogether. So that's one of those principles that's easier to recite than to apply in many cases. But in the present case, are we not, on the argument against you, facing really quite a simple situation where the deeming it amounts to an extension of the period of pensionable employment beyond the date of Denise's death until June 20th. Now, if you follow that, and we have to follow that because that's what C25 says in terms, then it must follow, by virtue of that self-same deeming, that she was still notionally in employment, in pensionable employment, sorry, whatever the word is, during that extension period, even though, in fact, she had already died after June the 6th.
Yes, I mean that's certainly the case.
So in that case,
point.
yes,
Sorry,
oh,
I'm so sorry, my lord.
Yes, in that case, you know, if you swallow all that which one has to do, then what is wrong with the argument that therefore, for the purposes of the termination of working out when it was that our pensionable employment came to an end, we have to look at the end of the extension period rather than the actual date when she did retire.
Well, in my submission, the fallacy, if my lord will forgive me for using that word, the fallacy in that argument is the underlying assumption that one cannot retire if, for some purposes, one's employment is deemed to have continued. That is the two are not the same thing. I can retiring, being an ordinary English word, means that I have given in my notice, left and stopped coming into work, and the regulation E2A says that in those circumstances I can get a pension. It's taking it a little too far in my submission to say, oh well, you haven't really retired because in some respects there's an accounting exercise going on whereby you'll get some more money for your holiday pay and we'll take some of it back because it is you haven't because you're obliged to pay contributions out of it, and by the way that will increase the pension that you get. It's by some small amount. It just doesn't work that way in my submission. Retire as the definition, the way in which retire is understood is without such concepts bolting on. You retire, although it's a perfectly ordinary English word. You retire, but you haven't really retired until these various other things follow on. It's a bolting on of a concept when there's no need to. That's the that's my point. And if I may turn now to the general law on this, again I would go back to Benyon at page 315, if I may. 315.
315. Yes.
That's in paragraph 18.6. And I'm sorry, it's
This is what you call the potency of the term defined. Yes.
Exactly.
Yes. Well, I think it's a well-known principle.
Yes, indeed it is. And we have here that I'm sorry, my pagination seems to have gone a bit adrift. But if we see at the top of page 16, it is impossible to cancel the ingrained emotion of a word merely by an announcement. This is sometimes called the potency of the term defined. And then there's a quotation from
Yes.
Lord Hoffman. a definition may give the words a meaning different from their ordinary meaning, but that does not mean that the choice of words adopted by Parliament must be wholly ignored. If the terms of the definition are ambiguous, the choice of the term to be defined may throw some light on what they mean. And then he continues, as in another case, although successor is a defined expression, the ordinary meaning of the word is part of the material which can be used to construe the definition. And then I needn't trouble the court to read the rest of the page unless the court wishes to do so. But one of the examples is of some interest, and that's at the bottom of the page. G4S PLC against G4S Trustees Limited. Perhaps it refers to a decision of Mr. Justice Nuji, as he then was. I'd invite the court to read to the end of the quotation at the top of the following page. It's not directly in point, but it treats pensionable service as having a clear meaning which precludes service which merely quantified entitlements already earned, as opposed to enabling further entitlements to accrue.
Yes.
So what I would submit is that a provision which treats pensionable employment as extended will not preclude a finding that one whose service has ended has retired from employment. Now, turning to the recent decision of the Supreme Court, again, this is just for general make general points on the construction of legislation.
Does this add much to what Benyon says?
Well, I think that you could perhaps, because it is so recent, it would be useful perhaps to have a look at paragraph 48. Page 240 to 241, sorry, 48 and 49.
Sorry, page
240 in the authorities bundle, the lady.
Yeah.
Shall I resume, my lord?
Tell you what?
Shall I resume?
Yes.
Okay. Yes. The reason why the case turned out as it did was that the appellate courts disagreed on the question of whether management or claims management services was a term which had sufficient potency that that one could ignore a literal application of a statutory definition. Or at every level up until the Supreme Court, it had been held that it did have that. As a matter of common sense, claims management services means that one's got to do something to manage it. Their lordships, four of their lordships, took a different view, but they don't. But the reason why I am citing it is that if there is a clear case of potency, as in my submission the word retire possesses, that fact should be, a draftsman's choice of that word should be respected and applied. It can sometimes be a very fine point as to whether a particular word or expression has the necessary potency, as Lady Rose's dissent makes that point with abundant clarity. It's at page 289. I'm not proposing to refer to it,
but you're making this point in order to deal with what? The definition of pensionable employment, or the definition of retire from employment?
Retire from employment.
Retire from employment, which is not a defined expression.
Indeed. That is my very point.
Yeah.
So, I mean, strictly speaking, this line of authority doesn't really enter the picture, because as you accept, you're not actually dealing with an extending definition.
Well, what I am saying is that the word retire should not be. It should be treated as one with potency, and therefore it should not have extra requirements bolted onto it before one can say that a particular employee has retired for the purposes of E2A.
And I follow that. Does it really come to more than saying we should interpret the word retire just as having its ordinary, normal, everyday meaning?
Oh, exactly so.
That's the potency you're referring to. It's not potency vis-a-vis a definition of the term retire, but rather just a more fundamental principle. Normally you interpret statutory language as having its normal everyday meaning in the absence of any contrary indication.
Indeed, that's precisely my point.
Yeah, I mean, the counter-argument here is we do find a counter-indication in the express words of C2, and that's really what the whole case is about, I think.
Oh, of course it is, yes. But to retire from something doesn't mean, et cetera, et cetera.
Thank you.
Yes, but that is exactly the way I would put my argument. I'm grateful to my lord. But now, just to conclude this part of the case before I go on to the AW8 point, where I shall endeavour to persuade the court to hear it. Denise, in her lifetime, elected to have her retirement benefits paid as a lump sum. She applied for her pension and her own. She applied for her pension. Her employment was terminated on the grounds of ill health, and her application for Tier 2 benefits was approved. Those are at pages 13, 23, 31, and 38, and 40. It does not mean that if that what I'm saying, if that does not mean that she retired, it is difficult to imagine what would qualify. Subject to anything else which the court might wish to ask me about, those are my submissions on the question of whether Denise retired. I would now wish to address the court, to persuade the court to hear the AW8 argument, and then, but perhaps it might be best if I were to say why it is that it would be proper for the court to hear it, and then I'll make the argument if I'm allowed to. Does that find favour?
Yeah.
I'm grateful. Until the close of oral argument below, the respondent had maintained that Denise had not become entitled to a pension at the time of her death because she had not made a claim in writing to the Secretary of State pursuant to Regulation T1. At the close of argument, the respondent did not concede the necessity of an AW8 in order for a pension entitlement to arise, but did concede that a failure to file an AW8 could be cured at any time, including by a personal representative after the death of the scheme member. There are two reasons why the issue would need, from our point of view, needs to be resolved. One within the regulations and one outside them. Now, I will concentrate on the one within the regulations because, and only briefly mention the one outside them, namely the tax point, which, though I should mention again, that there is no way that I would ask this court to resolve the tax question. It is merely a reason why it would be a good idea to have a resolution of the construction of these regulations. But the one within the regulations is this. It is, if I may, it really relates to the question of when the entitlement arose. Did it arise in Denise's lifetime when she retired in 2018, or will it only arise when her personal representative puts in the AW8? Will have a considerable effect on what interest is payable. And it is to be noted that until this concession that Mr. Campbell could put in an AW8, this concession was made in March, the position of the respondent was that there was no possibility of them receiving an AW8 anyway, because Denise had not qualified for a pension.
What's the provision of interest? Is regulation T8, is it?
It is, yes.
Yeah. And you say in your skeleton argument that Denise or the estate is entitled to interest whether or not Form AW8 has been filed, because as long as the Secretary of State's got the necessary information, which he has, then interest starts running.
That is my.
So why do we need to decide whether AW8 needs to be filed?
Well,
either way, you say interest is running. You may or may not be right about that, but your argument doesn't depend on AW8.
That is correct, if I may say so. But if I might suggest this, let us suppose that the court finds in my favour and finds that Denise earned the pension.
Yes.
It's still open to the respondent to say, well, you haven't filed your AW8. Until you file your AW8, you're not entitled, and because you haven't filed your AW8 until now, no interest. That's the that's the risk within the legislation that I would be exposed to if this were not decided.
Yes.
Right.
So that's why you want us to decide this question.
Yes, indeed. On the question of the tax, it's simply that there is a there is a risk that, indeed a strong risk, that the estate will be charged if there's a payment at 45% for tax, because the money hasn't been handed over until more than 2 years after the death. There is an issue if, however, it is held that she became entitled way back, during her time. Then there is another section of the tax legislation which says that payment is deemed to have happened when one becomes entitled. I won't say more about this because that would be to stray into revenue law, which is well beyond my competence. But that is the possibility, so I am advised. And if that is the case, it is necessary to know when she became entitled. As we are here and able to receive an authoritative decision, that is another reason why perhaps in the court's
This is a point that
discretion,
neither the Ombudsman nor the judge found it necessary to decide.
that is right, because because they found against me. Because they found against me, I could have come up with 100 AWAs and it wouldn't have done me any good.
Yeah, right. All right. Let's hear what Ms. Ling has to say about whether you should be allowed to argue this point.
My Lords, the question of whether an AWA is relevant to the issues before the Ombudsman arose out of the position that had been taken by the NHS BSA prior to the final determination of the internal matters, when the argument that was raised was that even if Mrs. Campbell had left pensionable employment by the time she died, she hadn't made a claim for a pension using the AWA form for her death, and therefore could not claim entitlement to pension. She'd have died in deferment and was not entitled to ill health benefits. That was the position from which the respondent withdrew following the hearing in 2000, earlier this year. And it was at no stage part of the dispute before either the Pensions Ombudsman or Mr. Justice Zacaroli as to when, what interest might be payable or for when it might be calculated. In any event, I say that it's quite clear when interest must be calculated from. It's calculated from the date on which the member retires from pension employment. That's T8 4 and under due date 2. So I say that this is the point that you raised at the outset, my Lord. It's the question of whether there's jurisdiction to even consider this point. The Court of Appeal only has jurisdiction to determine matters that were complained of to the Pensions Ombudsman, because that's all the Pensions Ombudsman has jurisdiction to determine under Section 143.
So this was not the subject of complaint to the Ombudsman, is that what you're saying?
Yes. Sorry, I mean, unless I've misunderstood the point being made, Judge, my understanding is that the question is the question of interest and what interest is payable. And it's certainly not my understanding, my Lord, that was any aspect of the complaint. The question was, what were the benefits to which Mrs. Campbell or her estate were, or indeed her survivors were entitled? Were they ill health retirement benefits or were they death in service benefits? And the calculation of those had not even, that question had not even arisen by that stage.
Yeah.
So I think that's really all I have to say on that point.
All right. Well, we will retire for a couple of minutes and see where we
I'm
go
so
from
sorry.
here.
Before the court retires, might I simply draw attention to, first of all, to say that my learned friend is correct in saying we didn't get into the question of interest either before the Ombudsman or through the judge or before the judge. But of course, but we did have to contend that the respondent was not entitled to rely upon the lack of an AW8 And if I might simply refer, without going into detail, just list a few pages in the supplementary bundle where the respondent had taken the point that we could not have a pension because there was no AW8 filed, and moreover...
As I understand it, that's no longer the respondent's position.
Well, the respondent's position is that, as I understand it, that we can now cure the lack of an AW8, but that would not necessarily operate retrospectively. What I understand them still to be contending is that no entitlement, assuming that I win on other issues, no entitlement under the AW8 would arise until the AW8 is actually submitted. That is, and that will have the knock-on effects. And what I can, if I can give the court just some page numbers of document correspondence where the respondent took the point that we could not get our pension because of the lack of an AW8, and it was too late to file an AW8 because Denise had sadly died. I'll just read off the page numbers, if I may, and then that will be all that I would have to say on the issue. There's a letter of the 5th of October 2018 at page 66. And then there is a letter following a detailed challenge by the appellant of the 5th of November 2018, and that's, you'll find the relevant part at page 71. And then the respondent's response on the 9th of January 2019, and that's at pages 79 to 80. The final word by the respondent before we approach the Ombudsman is at pages 82 and 83. All of those are from the bundle, and it shows that the history of them taking the point in front of the Ombudsman, in front of the judge. I did submit that they were wrong about that, and as I say, and we did get the partial concession. That's where we are.
If I may just add, as my lord, I think this is the first time today that I've heard that this is the reason for the dispute. So I'm entirely unprepared at this point to deal with it. But more to the point, in my submission, there would need to be an application to amend the notice of appeal, and I'm still unclear, in fact, as to what the dispute between the parties is. The authority that I've cited, the Sun Life Authority, which I think you have in the bundle, tab 20, page 305, does enunciate the principle that there should actually be a dispute between the parties on appeal for a court to adjudicate on. That's the principled position, but of course, part of the reason for the need for that principle is that the parties need to be clear on exactly what point is in dispute between them, what the implications of the resolution of the point are. I'm not sure I'm even clear on what the dispute is, because it seems to me to be quite clear from Regulation T8 that interest is calculated from the date of retirement from pensionable employment.
Well, it's the later of that day and the first day on which the Secretary of State has all necessary information to calculate the value. T83E.
So I don't have an E on my 3.
No, well, that's what Mr. Schmitz refers to in his skeleton argument.
I've got 4 T8. The due date meaning the later of, and then there's a whole series of yes. So I see that point, my lord, but again, I'm not really sure what the dispute is here, because this isn't about the question of when entitlement arises. Again, it seems quite clear that the trigger for the payment of interest, bringing that provision into play, is when the information required under T1 has been provided. And so there's no dispute there as to what the meaning of the word entitlement is and whether the requirement for information to be provided under T8 has any bearing on it. So the wording of the provision does seem to be clear, but again, it's difficult without the proper processes being followed to identify what the respondent's position may be and what the implications of the decision may be.
Right, well, we will now retire for a few minutes to see where we go from here. So please don't leave the courtroom.
All right.
Naomi, I did raise it in the grounds of appeal. I'll find it now to satisfy you.
Page 17 of the bundle.
Yes, I believe that's right. That's what I'm just looking for now. Thank you. So that when did you get them? Oh, I see. So you got some updated.
All right.
Mr. Schmitz, I'm afraid we're against you on your main point. We think that both the Ombudsman and the judge were right. So we needn't trouble you, Miss Ling, and we need not hear the second point that you wanted to raise. It follows, therefore, that we will dismiss the appeal. Reasons in writing will follow. You will get a draft in the usual way, which comes with a strict embargo, which means what it says. That will be your opportunity to correct our English, but not our reasoning. And we would hope that in the light of the draft judgments, you will be able to agree an order disposing of the appeal. You did want to say something about the cost limitation, I think.
Yes, I did.
I mean, the costs, as you appreciate, normally speaking, follow the event.
Yes.
Up to the limit, which Lord Justice Newey has laid down, but you wanted to vary the limit, I think.
Yes, so to reduce it to 0, if I may. I don't know if the court has received a a more recent application. I think it was put in either on Friday or Monday.
Not
which,
that I
giving
am
the,
aware of. I'm not saying it's not there, but
it gives details of the.
is this in one of our bundles?
No, it's not in a bundle. I can pass them up. Essentially, I refer to it because there's been a deterioration in the condition of the appellant. And have we got any more? Yes, we have.
Well, there was quite a considerable amount of money at stake here, wasn't there, had you succeeded?
Yes, there was.
And that's why Lord Justice Newey decided he would not reduce the costs to zero.
Yes, but on the other hand, the risk was, of course, as is now sadly borne out, that there are more copies here. Well, first of all, that well, first of all, as I say, his health has deteriorated. He is coming up to retirement age himself. He's a criminal legal aid solicitor. His earnings are not great, and because of the deterioration in his health, there can be no confidence that will even continue. Of course, although he did stand to gain a fair amount if this had been decided in his favour. Perhaps I'd better be quiet.
I think we're going to need a copy of the application because all this witness statement does is verify it.
I think, do you?
I've been given a page witness statement confirming the accuracy of the contents of the application, but I haven't got the application.
Yes. Yes, I have the application here. Have you got any more copies? Oh, I see. I think that that the court's associate has 3 copies of the application as well.
I've got the application, but not the witness statement.
I've got the statement, but not the application.
Okay. I have here. I have 2 copies of the application here. May I ask how many copies of the application the court has?
2. One, and I've got one.
I don't have one.
You don't.
No, I don't have one either.
Okay, well, I have 2 here, so if you hand those up to those who don't have it. And is there a shortage of the supporting witness statement as well?
I've got the witness statement, which simply says that the contents of the application are true.
Oh, I see. Yes.
Yeah. Well, I haven't, but if that's all it says, I don't really need it.
I think we now have sufficient copies of the application to go round.
Thank you.
Have you another copy of the application? I don't have one now.
Yes.
Yes, well, I needn't detain the court for long on this. It's apparent that this man is his situation is by no means an enviable one. The case did have sufficient significant importance, as recognised in the court below, and as is recognised here by the nature of the panel which was placed in order to deal with the matter. It is important that in regulations such as these, their meaning be placed beyond doubt, and this is and the best way to do that was by way of an appeal to this court, which of course permission was given in respect of. That I don't think I can say any more than that, than to say he's in a bad way, and and this is a case that was worthy to be brought not only for him but for many others, as noted by the Ombudsman himself. The Ombudsman has indicated that they should be that these rules should be reviewed, and and I think that a review is taking place. But as Lord Denning said in a case many years ago, a lot can happen to a bill. And so in the meantime, we need to know what these rules, which were not drafted with luminous clarity, actually mean.
Ms. Ling, what do you want to say about this application?
The respondent doesn't take a strong position on this application, my lord. The respondent did agree before the High Court that there should be no order as to costs, bearing in mind both the comments of the Ombudsman and the comments of Mr Justice Zacaroli in granting permission that the matter would benefit from consideration by a High Court judge. However, the High Court did look at it in a substantive and thorough and persuasive manner, as observed by Mr Justice Newey, and the respondent took the view that if Mr Campbell wished to pursue it further, that the normal cost consequences should apply. The NHS BSA is the custodian of public funds and must spend them according to the usual principles, and therefore does regard itself as obliged to pursue costs for this stage of the case. But as I said, that position isn't pressed particularly hard, and in the final event, the NHS really regards itself as being in the court's hands as to its decision on this matter.
Right. Should we do this in the judgment? We'll give you our decision on this question in the draft judgment.
Thank you. Would the court require us to be present when it's handed down?
Oh, no. All hand downs these days are electronically done. We don't do it in open court anymore. Anyway, thank you very much for your argument.